The Arbitration Fairness Act is a bill that would amend the Federal Arbitration Act by adding a new chapter invalidating agreements that require arbitration of employment, consumers, antitrust, or civil rights disputes entered before a dispute arises. Arbitration can be a suitable alternative to litigation if the consent to arbitration is truly voluntary and occurs after the dispute arises. Most consumers are unaware that they've signed away their rights to be heard in court. There is overwhelming evidence that forced arbitration creates an unaccountable system of winners and losers. Forced arbitration does not provide the important procedural guarantees of fairness and due process that are the landmark that is done through the courts. The Arbitration Fair Act will restore the intent of the original Fair Arbitration Act, passed by Congress in 1925. The FAA was intended to target commercial arbitration agreements between companies, but the Supreme Court broadened the reach of the law to include consumers and employment disputes, effectively superseding all other federal laws protecting consumers and workers. The AFA seeks to ensure transparency in civil litigation by protecting the integrity of the Civil Rights Act, the Equal Pay Act, the Americans with Disabilities Act, and the Age Discrimination in Employment Act, and others that are frequently forced into arbitration by companies. The Arbitration Fair Act is a common sense reform that would restore the rights to challenge unfair practices by corporations and ensure meaningful legal recourse when people are wronged.